कि अच्छा आप आ तो गए हैं, लेकिन कम से कम मुझे ये तो बताएं कि आप क्यों आए हैं। तो दूसरा एक लॉजिकल कंक्लूजन ये निकलता है कि उस आदमी को ये बताना है कि उसको हम अरेस्ट करने आए हैं। दैट मीन्स दैट ग्राउंड्स ऑफ अरेस्ट आर रिक्वायर्ड टू बी इमीडिएटली टोल्ड टू दैट पर्सन। चलिए ये दोनों चीजें भी हो गई, पुलिस वाले वर्दी में है, नाम भी अच्छे से दिख रहा है, उनका ओहदा, डेजिग्नेशन, एवरीथिंग इज क्लियर। उन्होंने उस शख्स को ये भी बता दिया है कि हम आपको इस अपराध के लिए गिरफ्तार करने आए हैं। लेकिन विद इन अ फ्लैश, विद इन अ मिनट उसको उठाया और गाड़ी में डाला और उसको ले गए। द फैमिली इज शॉक, द नेबर्स आर शॉक, व्हाट हैज हैपेंड ऑल ऑफ ए सडन। तीसरा राइट यहीं से निकलता है कि अगर उसकी अरेस्ट करते हैं उसी समय एक मेमो, अरेस्ट मेमो बनेगा। उस अरेस्ट मेमो में लिखा जाएगा कि किस जगह, कितने बजे, किस दिन उस शख्स को हम अरेस्ट कर रहे हैं, और उस अरेस्ट मेमो पे उसी समय एक फैमिली मेंबर के दस्तखत लिए जाएंगे। अगर उसके घर में कोई फैमिली मेंबर नहीं है तो उस लोकेलिटी का एक रिस्पेक्टेबल पर्सन, एक सम्मानित व्यक्ति को बुलाया जाएगा, वो उस पे बतौर साक्षी दस्तखत करेगा। उस अरेस्ट मेमो की एक कॉपी पुलिस अपने रिकॉर्ड में रखेगी और विद इन 24 आवर वो अरेस्ट मेमो की कॉपी भी कोर्ट में आएगी। ये सबसे इंपॉर्टेंट है। ऐसा नहीं है रहा चलता। अब एक सवाल उठता है कि अगर सपोज वो आदमी सड़क पे घूम रहा है, उसको अचानक से पुलिस वाले पकड़ लेते हैं, उसके खिलाफ मान लेते हैं कि उसके खिलाफ एक आपराधिक मामला बनता है, लेकिन उसको सड़क पर से उठा लिया। अब उस समय अरेस्ट मेमो कैसे बनाए? तब भी अरेस्ट मेमो बनेगा, लेकिन उसी समय जो अपराधी को गिरफ्तार किया गया है वो बताएगा कि मेरा ये रिश्तेदार, मेरा मित्र या मेरा परिवार का ये सदस्य है, उसका ये पता है, आप उसको इतला करें कि मेरे को आपने अरेस्ट कर लिया। सो दिस इज अ वेरी इंपॉर्टेंट राइट। His immediate relatives, his family members, or any of his close associate has to be immediately informed that a person has been picked up.
Can I just to add here, sir? This is very important. D.K. Basu, as Manoj Jain ji has explained, as the first time in 1997,
arrest memo in such type of matters is paramount. Rather, I feel, personally speaking, I would say that such type of arrest memo should be always made in duplicate. And one copy should be immediately left with the person who signs that arrest memo on behalf of the family of the accused. Otherwise, there is a chance of interpolation or adding something. So the police is now acting in a very transparent manner and scrupulously following all the guidelines laid down in D.K. Basu case or as now contained in CRPC by virtue of Amendment Act number 5 of 2009. But still I feel it is not amply clear that it has to be prepared in duplicate. In order to show complete transparency, it would be probably more appropriate if one more copy is prepared and immediately left with the person who signs such arrest memo as witness. Now, when the arrest memo has been prepared, but that is not the end of the matter. Thereafter, the police is required to prepare an inspection. Most of the incidents related to torture are taking place during the period when the person is picked up and the person is produced before the court. That period is very crucial. Normally, when a accused is produced before the court for the first time, he says that he was tortured and third degree was used, and then we always insist, where is the medical report? Now, by virtue of the guidelines contained in D.K. Basu, by virtue of constitutional provision, it is now obligatory for the police to take such person to the medical officer also for proper medical examination. He has to be taken to state-run hospitals, to central government hospitals, not to a private hospital. And at the spot, whenever the person is arrested, there has to be a preparation of inspection memo. In the inspection memo, the arresting officer is required to describe whether there was any injury, even if it is minor, even if it is major, these are required to be mentioned. There might be a case that the person might be having injury already at the time of arrest. Rather, it is for the benefit of the police. If such type of inspection memo is prepared, the police can always show to the court that look, this particular injury was existing when the person was arrested. So you cannot follow up the police official for such injury.
That is probably to say something that is
rather for the benefit of police officers, for the benefit of arresting officers. And if arresting officer does not comply with the provision, then what? The important thing is that it has to be complied, because at least this provision is for the benefit of the police officials. So inspection memo has to be prepared. And then the most important thing is that when any such person who has been arrested is brought to police station, there is requirement of maintaining a case diary for that particular purpose itself. That yes, the police officer has arrested such and such person at such and such time, and such relative or friend of the person has been duly informed. Not only this, there is a direction to create police control room at district level, at state level, and there also the entire such record is required to be transmitted, so that any person can go there, can walk in at such control room and can check as to who has been arrested. He might be searching for some near and dear one, and he might not be even knowing that his near or dear one has been arrested. He can always go to the control room, and from there he can see the data. And after the medical examination, the most important thing is production of accused in the court of law within 24 hours. The police is not obliged to confine any such person beyond 24 hours. I can understand if they can legitimately exclude the journey time. But otherwise, it is the mandate of the law also, various judicial pronouncements are also there, that such person is required to be produced in the court of law within 24 hours. I think that is the most crucial aspect of the case, because even third report of National Commission of Police indicated that most of the custodial deaths are taking place during that period. And whenever, as a magistrate, I would say that as a magistrate, when any person is produced before the court for the first time, it is required for any magistrate or for any other court to go through the record entirely. And it has to be ensured that all the guidelines contained in D.K. Basu case and all the statutory provisions contained in Constitution of India and CRPC have been properly and scrupulously followed by the police agency. It is rather required on us to see arrest memo. It is required for us to see the inspection memo. It is required for us to even see whether the accused has been taken to any hospital.
There's a call. We will take one call. Yes. Yes. As an evidence. What do you say, sir? Yeah, that will be.
Now, yes, there are recent amendments in the law which even say that even the recording of evidence in the court is permissible through audio-video linkage. So, if the technology is applied at the threshold of the case. The threshold of the case, when the accused is produced, is arrested and is produced in the police station or is brought to the lockup for the first time. We can see the manner of his movement right from there. So it is. I think in Delhi at least we are lucky that these CCTV cameras are there in place, and we hope that these CCTV cameras are installed, if not already installed, in all the states, across every village, every nook and corner. It would be very helpful for each of us. And talking about D.K. Basu, I think most of the guidelines have been covered, but one very important aspect is still required to be discussed, that is providing of counsel. That is very important. If the person is picked up, he has been brought to police station or he has been put in a lockup, he is required to be interrogated. Naturally, the police has picked him up for interrogation purpose only. Now, before that, he has a right to be consulted by his counsel. That valuable right cannot be denied to him. It is, arresting officer has to ensure that if that person says that he wants to consult a counsel before interrogation starts, it is the duty of that arresting officer to inform that counsel so that that counsel can come to police station and can have a word with the person who has been put under arrest. Rather, I would go a step ahead. Even if that person does not say so, that he wants to engage a counsel or he wants to bring his counsel, or he is not aware that he can, before interrogation, he has a right to be consulted by counsel, the police agency, the arresting officer, should also make him aware that he has this valuable right, and if before start of interrogation he wants to be consulted, he can be provided a counsel.
Yes, what is the question? Yes. Haji? Yes, can we take a question? Haji?
Sir, I want to ask one question.
Yes.
Hello?
Proceed. Yes, proceed.
Sir, I am Aarti.
Yes.
I am Aarti.
Yes, boliye.
I just want to ask one question. That what action can the magistrate take in case the police does not make compliance of the directions issued in DK Basu case? Should I repeat?
Yeah, sure.
No, this is,
What action
Yeah.
can the magistrate take in case the police does not make compliance of the directions issued in DK Basu case?
Thank you. Yes. Manoj Jain. Yes.
Aarti, you have put a very, very good question, I must say. I was rather about to touch that aspect also, but since you have come up with this question at this stage, I would simply say that the answer is contained in DK Basu itself. Whenever as a magistrate, suppose I am sitting as a magistrate, the person is produced before me for the first time. In any eventuality, I have to receive within 24 hours the copy of arrest memo, the copy of inspection memo. And the accused is also required to be produced before me within 24 hours. The case diary would be before me. If these things are not there, if I come to know from the case diary that the arrest memo is not there, inspection memo is not there, or the accused was not produced before any government hospital for medical examination, in that situation, it is already mentioned in DK Basu case that it would rather amount to contempt of court. And as a magistrate, I can make a reference, and the reference can always be taken to its logical end. Contempt of court is not a small thing. It can also invite parallelly a departmental action, and the erring official can be taken to task at the level of department also, besides they being made to face contempt of court.
Simply we can say it cost his job. Policeman's employee.
Yes.
It cost his job.
Yeah, there is another question. Yes.